Welcome to the Disability Granted channel. You suffer a severe disabling condition, you've got no job, little income if any, you've got inadequate health care, you've got bills, more bills, and maybe less friends. You need to apply for a Social Security disability. You need both financial and medical benefits. But experts publish these discouraging numbers. You see them on the internet, you see them on websites. You may even hear people repeat these numbers. The experts, the authorities, will tell you that only 30% of Social Security applications are approved. Only 30%. That's rather discouraging. Is it true? No. No, it's not true. You can only get the figure that low if you include technical denials, which have nothing to do with disabling conditions. In Social Security studies for disability medical determinations, technical denials are particularly excluded. Social Security doesn't use them in making any such determination. Social Security excludes them because technical denials generally lack evaluation of any medical evidence. So, what are technical denials? Well, they're not disability determinations. Disability determinations are made by the Disability Determination Services. That's where the disability examiners are. Social Security tells us that the field office is responsible for verifying non-medical eligibility requirements. The field office is responsible for verifying if the application meets required technical requirements. If it does, if the application meets those requirements, it sends the application to DDS for evaluation of disability. And DDS is responsible for developing medical evidence and making the initial determination on whether or not a claimant is disabled or blind under law. So why do some authorities measure your chance of being granted Social Security disability by including every case which was technically disapproved without a disability determination? Something's not right. Social Security actually shows us how many applications for disability were medically approved. It's closer to 45%. So what are the common technical denials used to dilute your success rate to 30%? Let's look at common technical denials which have been published by the administration. Social Security says it will technically deny any application, either SSI or SSDI, for disability for the following 9 technical reasons. Number 1, your application will be technically denied if you're not an American citizen or a resident legal alien. Does that have anything to do with determining disability? No. That has nothing to do with the applicant's disability, if any. 2, your claim will be technically denied if your application has already been made and denied. And this is something you need to realize. Too many people, if they get notice of disapproved claim, they appeal by just filing a new application. You do not appeal by filing a new application. Matter of fact, in the notice of disapproved claim, they tell you how to appeal. They tell you to file a request for reconsideration, and they even provide that document to you with instructions. And it's not like it's a hard document to complete. But you do not appeal a denied application by filing a new application. You do not appeal an unfavorable reconsideration by filing a new application. You don't appeal an unfavorable determination by an administrative law judge by filing a new application. You don't do it because it will be technically denied. At this point, we're just talking about applications. We're talking about technical denials of applications because we're seeing all these figures that are very discouraging to disabled people. We're seeing figures that only 30% of disability applications are approved. There's no disclaimer to it. There's nothing. They just put it out there like that. They don't tell you that applications are approved at a 45% rate when they have a medical determination. It's not a technical determination based on something completely not involved with disability. Your application for Social Security disability, whether SSI or SSDI, will be technically denied if you don't cooperate with your disability examiner. If you don't cooperate with your disability examiner, he or she cannot complete your claim. You have to cooperate. Don't get defiant. Don't let people encourage you to be defiant. Don't let people tell you that the disability examiner is out to get you. Just cooperate. If the disability examiner calls you, call him back. If the disability examiner asks you or sets up a consultative examination for you, attend it. If the disability examiner asks you to complete a form, and you're going to see that in here too about completing forms, do so. Look, the people that get approved by a disability examiner. You want to be one of them. Number 4, your application for Social Security disability will be technically denied if your claim can't get processed because your whereabouts are unknown. How can a disability examiner contact you to get more information, contact you to get you to complete forms if they're required? How can they even get a status of you if they don't know where you are? If they don't have a phone number? At least give them contact information of a family member or a close friend so that they can get to you through your contact. Don't let it be whereabouts unknown. Don't be the mystery person. You can't contact me. Don't do that. Number 5, your application for Social Security disability will be technically denied if you don't attend your scheduled consultative examination. And too often I see sources, even authorities, warning against the consultative examinations, that the doctors are out to get you, that they're hired by Social Security for one purpose, and that's to prove that you're not disabled. That's ridiculous. This channel is producing a video on consultative examinations. You may want to watch that. Go to your consultative examination. Don't go with the chip on your shoulder. Don't go thinking everybody's out to get you, unless your disability is paranoia. If you miss your consultative examination, again, the disability examiner can't complete your claim. And if the examiner can't complete your claim, has to deny it. You have to cooperate with your disability examiner too. If you have any questions about it, ask the disability examiner. Why do you need this? You might say, can I have my own doctor do it? And they may tell you yes. If your doctor is qualified to do consultative examinations, if your doctor can do them, you may ask them whether your own private physician can do the consultative examination. And if your doctor is knows how to do consultative examinations. If your doctor is qualified to do them, Social Security might well say, yes, we just need it. We need it. Get it from your doctor. But if your doctor is not qualified, then they likely will have to send you to a doctor that is. Your application for Social Security disability will be technically denied if you don't complete forms required by your disability examiner. These are forms which you are required to do. It's not like the disability examiner just said, oh, I've got a form. I made up a form. I want you to. It's not that. These are forms which people applying for disability must complete. Even the application, you have to complete it. Many people don't complete their application. They leave things blank. You have to complete the application. If the disability examiner asks you to do so, do it. And there are other forms that you provide. And these forms, you need to do these forms to prove your disability. The burden of proving your disability is on you. Until you prove you're disabled, as a matter of law, you're not. So at the application level, the forms include your application, as I mentioned, an adult disability report, an adult function report, maybe a work history report or work function report. You also need to sign an authorization to disclose information. That is a form that requires very little other than signing it. Number 7, your application for Social Security disability will be technically denied if you don't authorize the Social Security Administration permission to contact financial institutions and request financial records. That's required. Your application may be denied upon your death after the field office transfers your disability claim to the Disability Determination Services. It may not be denied. Your estate may be allowed to continue it. Abatement may be appropriate under certain conditions. Abatements where the claim just simply stops. Have you noticed one thing? Do any of these technical denials have anything to do with whether you suffer a disability? No. None of these technical denials have anything to do with any kind of questions as to whether or not you're disabled. If you think this video will be helpful to other disabled people, please share, like, and subscribe. Thank you for watching the Disability Granted channel, and good luck.